Good morning. I am Dr. Ritu Gupta, Faculty, National Law University, Delhi. In today's module, we'll discuss vertical agreements under Competition Act 2002. Let us have an idea about the module. What are we going to discuss today? Today we'll talk about the Competition Act 2002 as it deals with vertical agreements. Section 3, subsection 4 of the Act describes agreement amongst enterprises or firms or persons at different stages of the production or supply chain in different markets with regard to the goods or services to be anti-competitive. If such agreements causes or is likely to cause an appreciable adverse effect on competition, then that would be falling under this section. The inclusive nature of the definition has been discussed along with the types of such agreements. Since such agreements are not bad per se, as we had discussed in the previous module, rule of reason has been applied by the Commission in its various judgments. Various market forces that are needed to find about anti-competitiveness of such agreements that we are going to discuss today. Section 19, subsection 3 will talk about that also briefly. Further, if such arrangement amongst the enterprises cause adverse effect on competition, these are prohibited under section 3 of the Act. Also, impacts of such agreements on competition in India we are going to discuss in this module. For understanding the provisions of this module, basic knowledge of anti-competitive agreements and the related provisions in the Competition Act 2002 is needed. Let us talk about the objectives of this module. The main objective of this module is to discuss the provisions of the Competition Act 2002 as far as they are applicable to vertical agreements. And by discussing this content, we will apprise the students of various types of vertical agreements as per the Act. By discussing these contents, again we are going to make students understand the impact of such vertical agreements on the competition as it works in India. The Competition Act 2002, the antitrust legislation in India, aims at preventing practices that have appreciable adverse effects on competition in India. Anti-competitive agreements are prohibited under section 3 of the Act. Let us see what is the definition of vertical agreement. The term vertical agreement has not been used in the Act as such. Section 3, subsection 4 of the Act, however, provides for certain types of anti-competitive agreement between or amongst the firms or enterprises at different stages or levels of the supply chain of the products or services. Let us have a quick view of the section as per the Competition Act 2002. Section 3, subsection 4 states, any agreement amongst enterprises or persons at different stages or levels of the production chain in different markets in respect of be it production, supply, distribution, storage, sale or price of trade in goods or provision of services, including tie-in arrangement, exclusive supply arrangement, exclusive distribution arrangement, refusal to deal, tie-in, resale price maintenance, shall be an agreement in contravention of section 3(1). If such agreement, what we have to see, the section provides that if such agreement causes or is likely to cause an appreciable adverse effect on competition in India. So what is to be seen here as provided by the section is the effect of such competition in India. Section 3 subsection 1 and section 3 subsection 2 read together with section 3 subsection 4 prohibit such agreements and declare them to be void. Section 2 subsection M of the Act defines the term practice as any practice relating to the carrying on or any trade by a person or an enterprise, and section 2 subsection A further defines activity as a term that includes any profession or occupation. We can use section 3 subsection 5 also, which provides for certain exceptions in the situations where restrictions imposed by subsection 3 and subsection 4 of this section do not apply. Let me introduce you to the concept behind this content. To increase their profits, the firms at different levels of the production chain may enter into such agreements amongst each other that may affect the competition adversely. The intention of the economically stronger party behind such arrangements is to compel the other party. It means to force the other party, force where one is not willing to but one is forced to do so, to enter into such agreements, like where be it supply of goods or of services, and which is the subject matter of such arrangement, and this party wants to have this arrangement or agreement in its own favor. Let us here at this point talk about what do we understand by the term market power. The market power of the firm enacting vertical restraint is very important. If the said firm does not enjoy combination of market power to its side, that is, there already exists enough inter-brand competition in the market regarding those particular goods or services which are produced by the firms which are involved. That firm is manufacturer firm, then the alleged vertical restraint will not have any major effect on competition in the market. Let us see here that market power is different from dominance. We cannot compare, we cannot use both the terms interchangeably. Market power here refers to the power over price, and it may occur even in situations where no firm has dominant position. By discussing these contents in this particular module, what we'll learn at the end is the concept of vertical agreements as provided under the provisions of Competition Act 2002. We'll try to find various types of vertical agreements and the inclusive definition of this type of vertical agreements as provided under section 3 of the Act, and we'll learn the factors under section 19 subsection 3 that should be considered when we are going to look into the anti-competitiveness of such arrangements. Also, after discussing these contents, we'll be able to know about exceptional situations which have been laid by section 3 subsection 5, where prohibitions under section 3 are not applicable. Now, let us talk about regulation of vertical agreements. Vertical agreements were prohibited per se earlier, while rule of reason is being preferred by the court now to evaluate vertical restraints. The Indian competition law is in tune with United States competition law as far as applicability of rule of reason is concerned. If we see the case of Tata Engineering and Locomotive Company Limited versus Registrar of Restrictive Trade Market agreement is a landmark decision of Supreme Court of India, which aptly illustrated the applicability of rule of reason in the cases of restrictive trade practices. The Supreme Court in this case held that the following three issues should be considered to determine whether a restraint suppressed or promoted competition. Those three factors were facts peculiar to the business to which the restraint is applied. The second factor was the condition before and after the restraint is imposed. And the third factor was nature of restraint and actual as well as probable effects. Now I would like to discuss the types of vertical agreements as provided under the Indian Competition Act 2002. The explanation to subsection 3, subsection 4 provides definition to each such type as in the following words. Let us see. First of all, we have tie-in arrangements. Tie-in arrangements include any agreement requiring a purchaser of goods, a condition of such purchase to purchase some other good. That is how we see that any agreement which requires a purchaser to purchase some goods, which is going to be a precondition of such purchase to purchase some other good. This is an arrangement by which a seller agrees to sell a product known as the tying item only on the condition if that buyer agrees to buy a second product known as the tied product from the seller. Such arrangements not only reduce or eliminate the competition completely, but also remove buyers' resistance to the tied product. This is very important here. Following tie-in arrangements were held to be in restraint of trade. Another case, if we can take, in Hindustan Motors Limited case, where it was held that requiring the buyers of cars to pay towards the servicing of car with the sale price amounted to tie-in sales. And another case which we can see was in Anand Gas case, requiring customer to buy gas stove while giving gas connection. The second category of this type of vertical agreements is exclusive supply agreements. Exclusive supply agreements include any agreement restricting in any manner the purchase in the course of his trade from acquiring or otherwise dealing in any goods other than those of the seller or any other person. We can see the recent case of Jindal Steel versus Steel Authority of India Limited, Jindal Steel versus SAIL. Here an exclusive supply agreement through a memorandum of association, that is MOU, was entered into between Indian Railways and Steel Authority of India Limited. This particular agreement was related to supply of rails, and that had to be on a continuous basis. Jindal Steel and Power Limited alleged that the said MOU, that is Memorandum of Understanding, resulted in foreclosure of the relevant market for it. So in this case, it was held that the MOU was not hit by section 3 subsection 4 and hence it didn't amount to anti-competitive agreement. In the case of Consumer Guidance Society versus Hindustan Coca-Cola Beverages Limited, this was another case where dealing with exclusive supply agreements was held. The third category of vertical agreements here, as provided under section 3 subsection 4 of the Indian Competition Act 2002, is exclusive distribution agreements. Exclusive distribution agreements include any agreement to limit whereby the power of the one of the parties is limited, restricted or withheld, whereby the output or supply of any goods or to allocate any area or market for the disposal or sale of the goods. The main feature of such agreements is that the manufacturer or supplier agrees to supply certain goods for resale to only one party. The exclusive distributor within a defined territory, and no other party will be supplied with the goods within that area by the supplier. Thus, exclusive dealing is a way of restraining inter-brand competition. Another type of vertical agreement as provided under section 3 subsection 4 is refusal to deal. Refusal to deal includes any agreement which restricts or is likely to restrict by any method the persons or classes of persons to whom the goods are sold or from whom the goods are bought. Again, it's a sort of boycott. It means refusal to buy or refusal to sell by a mutual agreement, and where the intention becomes important. You can see here that the intention to restrict competition by this type of mutual agreement is illegal. Refusal to buy, refusal to sell, where this intention is reflected, that would again be illegal. This is very important here. The Act, however, does not empower the authority to decide on behalf of any of the parties whether they should enter into any particular agreement or not. To deal or not to deal is the freedom of the enterprise, which is in spirit with our law of contract and the spirit of our constitution as well. And the enterprises can choose not to deal with any specific firm or person. But what we have to see is the position of competition law here. In the situations where such refusal to deal falls within the definition of the Act, the behavior of the enterprise is said to be anti-competitive. To understand this refusal to deal better, here we can take the case of Kapoor Glass Private Limited versus Scott Glass Private Limited, where the Competition Commission of India held that the joint venture is anti-competitive, since in this particular case it was created to finish off competition in the downstream market. And again, one more thing was here, that various agreements were in contravention of clauses A, B, D and E of section 3 subsection 4. Next category of anti-competitive agreements as defined under section 3 subsection 4 clause E is resale price maintenance. For in short, we can term it as RPM. So this resale price maintenance includes any agreement to sell goods on the condition that the prices to be charged on the resale by the purchaser shall be the prices stipulated by the seller, unless it is clearly stated that the prices lower than those prices may be charged. RPM is a form of price fixing, this we can say. And to illustrate it further, let us take example of a manufacturer Y and its distributor Z. They may agree that the distributor will sell Y's products at certain prices or at above a price floor, which we term as minimum resale price maintenance, or at or below a price ceiling, maximum resale price maintenance. If Z refuses to maintain prices, a reason may be any, due to whatever reason. If he does so, Y may stop doing business with it. Thus, we can say every case of resale price maintenance is to be judged on the basis of its effects to establish its nature. And usually, branded goods are subjected to resale price maintenance as opposed to non-branded goods. However, resale price maintenance may prove beneficial in the following ways, and the ways can be ensuring effective retail services or addressing free rider problem. Like free rider is someone who enjoys the benefits of someone else's investment. That person is free rider. So whosoever addresses this free rider problem would fall here in this category. Limiting inter-brand competition among its retailers. Also, there are certain situations which we are going to take up just now, where RPM may not be a restraint of trade. Such situations can be if manufacturer was in a position to use its dominant power, then it would much rather use it through wholesale prices instead of going into resale price maintenance agreements. Or if the situation is that a product or service might require brand specific promotion by the retailer. Such a promotional activity involves cost on retailer. If we talk about the inclusive definition, since the definition of vertical restraint which has been provided by the Act, that is the Competition Act 2002, the definition is inclusive. There may be other types of agreements that may fall in the definition. To determine whether such agreements are anti-competitive or not, what we have to do? Careful market analysis of the effects. So, careful analysis of the factors which are there in the market and what is the impact on the enterprises. This is what we have to see here. There are certain exceptions to vertical restraints which have been provided under section 3 subsection 5 of the Competition Act 2002. Now in this module we are going to discuss those exceptions in detail. Section 3 subsection 5 states that the exceptions to those vertical restraints are, these can be agreements permitted by law, the right of any person to restrain any infringement of or to impose reasonable conditions as may be necessary for protecting any of his rights conferred him under, there are 6 categories are there, the Copyright Act 1957, the Patents Act 1970, the Trade and Merchandise Marks Act 1958 or the Trademarks Act 1999, the Geographical Indication of Goods which we call as GI, Registration and Protection Act 1999, and then there is the Designs Act 2000 and the Semiconductor Integrated Circuit Layout Design Act, that is also 2000. Now let us talk about right for exclusive export. The right of any person to export goods from India to the extent to which the agreements relates exclusively to the production, supply, distribution or control of goods or provision of services for such export. Hence, we can say that in view of the discussion here, even if any agreement falls within the prescribed definition of vertical restraint, it would not be anti-competitive if it is hit by any of the exceptions as we just discussed. Let us now see what are the factors that we should consider when we are deciding whether a particular agreement in the market between the enterprises amounts to vertical agreement or not. The Competition Commission of India should, while conducting any inquiry into the alleged anti-competitive behavior of the enterprise, should examine various factors and circumstances. Section 19 subsection 3 provides for various situations that may result if any of the above types of vertical agreements is present in the market, and this we can discuss. First, we have creation of barriers to new entrants in the market. This is again very important factor which has been mentioned. So whenever we are to decide whether when Competition Commission of India is to decide whether particular agreement falls into the category of vertical agreement or not, it will see whether creation of barrier to new entrants in the market is resulted or is caused or not. Another factor which we may consider may be driving existing competitors out of the market. Again, first factor was about entry and this is about exit. Then third, we have foreclosure of competition by hindering entry into the market. Then accrual of benefits to consumers become very important factor here. The next factor is any improvement with regard to the production or distribution of goods or provision of services. And one more factor which has been prescribed over there, it's promotion of technical, scientific and economic development by means of production or distribution of goods or provision of services. The situations which we have just discussed in the first 4 factors, they are negative, while that which we discussed in the last 2 factors, these can be termed as positive situations. And thus we can decide on the basis of these grounds or the standards as were mentioned in the above position. They are quite open-ended, vague and difficult to determine, because when you are not fixing any limit or posing any restriction, then it becomes very difficult at times for the authorities to consider such factors. And moreover, we can say that every type of vertical agreement is to be judged on the basis of the above parameters. Now let us talk about appreciable adverse effects on competition. What do we understand by the term appreciable adverse effects? Section 3 of the Competition Act uses the term appreciable adverse effects on the competition. The said term examines the agreements which cause or is likely to cause an appreciable adverse effect on competition within India. Adverse effect may be said to occur when the said agreement harms the spirit of competition in the country. The harm should be on the consumer welfare in the sense of economics, that is effects on the prices or output of any product. Only then the agreement would be said to be anti-competitive. The word appreciable is also too fluid and vague because it has not been defined. What we do is to see overall lot of scope has been left by the law that gives way to adjudicate, approach and multiple interpretations. Also, here we can see that no exemption has been given by the vertical agreements on the basis of threshold level as has been done by European Commission. European Commission gives block exemptions, what we term as de minimis exception, which we'll be discussing in the next module. Now in this module further we are going to discuss what is relevant market, which is very important term again here. Section 3 subsection 4 uses the word different markets. The term relevant market is to be needed to determine appreciable adverse effect on the competition. The relevant market is where the demand and supply interact, or the area of competition where the other party operates. Section 2 subsection R defines relevant market with reference to relevant geographic market or relevant product market. But what we can say, there are no standards or effective guidelines as such in the Indian Competition Act 2002 to determine relevant market. Hence, it becomes a complex mix, and the Competition Commission of India, which is the regulator, faces real challenges and great difficulties when it has to determine the same, that is the relevant market, there in the situations which are there in both section 3 as well as in section 4. And ultimately the burden is on the Competition Commission of India to prove that a particular agreement is anti-competitive, and if it is anti-competitive then it should be prohibited. Let us now conclude what we have learnt in this module. Here we have seen that the term vertical agreement does not find a place in the Competition Act 2002 as such. Section 3 subsection 4 of the Act, it provides for agreements amongst enterprises or persons or enterprises which are operating at different stages or levels of the production chain in various markets with respect to any of the production, supply, distribution, storage markets with respect to all of these, or trade in goods or provision of services. Such agreements are referred to as vertical agreements. This is what we see, and that's why they are prohibited under section 3 subsection 1. The rule of reason is used to determine the nature of vertical agreements, since in the definition the term is used which causes or is likely to cause appreciable adverse effect on competition. Exclusive supply and distribution, tie-in sales, resale price maintenance, refusal to deal, these are few of the vertical restraints which have been expressly mentioned in the Act and that we discussed here. Through there could be many other types that may fall under this description. The definition of each of the vertical restraint is also inclusive. That means that there is lot of scope for other vertical restraints as well, and even if not prescribed under any of these subsections as we have just seen. Section 19 subsection 3 further provides for the factors that may be considered while evaluating the effects of such agreements. So in this module we have discussed all the contents as we had envisaged in the objectives. I hope this module was beneficial to you. Thank you.